hardly any evidence presented of any computer virus. There was no theory of computer virus presented. The evidence presented overwhelmingly showed that the machines function correctly, including the last two parallel tests and the certification of those tests, where the Secretary of State stated that they 100% accurately reported the votes.
So what's the explanation for the 18,000, so to speak, mystery or missing votes?
Weren't you at this hearing? Did you hear it?
I heard some different things, but I still couldn't figure out what the...
I'll tell you what it wasn't. It wasn't machine malfunction.
So it was just the voters weren't smart enough to vote that race?
No. You know better than that. You heard the evidence.
I heard.
Anything else?
Thank you very much, sir.
Okay.
Sure. What about the theory that they can't figure out if there's a violation in the code?
You know, the issue is that the court has to balance the legitimate interest of trade secret holders and the interest of the state in maintaining security of its systems with the interest of the plaintiff. And the problem is that the plaintiff can't just come here with no evidence and say, hey, you know, until I look at the source code, I can figure it out. Well, I can claim that, you know, some car ran me over because it had some computer program in its memory that I have to read that may be a secret. Unless I have some evidence, no court has ever ruled that you can come, because it is a trade secret case tried within an election context, the court has to factor in the very legitimate and compelling interest of the state in maintaining security of its systems.
Okay. But as you said yesterday, you don't object to the state doing its review of the code,
of course
or
not.
Possibly some independent
the
review
state,
set up
and
by
see,
the court.
that's part of the fallacy that the other side has stated in their sound bites, that we're afraid of someone reviewing it because they're going to find something. This has been reviewed by federal agencies, state agencies. This is held in escrow by the state. You know, our software is under a licensing agreement to the state as well as the supervisors. The appropriate individuals that have a duty to maintain the security of election systems in Florida have reviewed it. And what we told the judge is we do not have a problem with those folks conducting a source code review, which they are, by the way. They're finalizing those protocols. And we don't have a problem with the judge getting an independent expert to review that process. And if there's a problem, that independent expert could go to the judge in camera and say, look, judge, I think there is a problem and I think that they should be able to look at it, and the judge can make a decision. The problem is at this point there is no factual basis whatsoever to justify their demand. Okay?
But some would argue that the state is not, that they're supposed to conduct elections in an open and transparent way, and keeping that code in secret means the public cannot actually observe how it's done.
But that's your point of view. That's not the legislature's point of view. The state has already set policy, and you have every right to go across the street to the legislature and advocate that position and change the law.
Ironically,
but the law is what it is, and I'm not going to argue.
Ironically enough, with this catch-22, the legislature gets elected by those machines.
The plaintiffs almost seem to be arguing in their cross today that the fact that these were all agritronic machines in your witnesses report that I almost seem to be coming saying, no, this is just that support their argument that there could be a problem with it.
Absolutely not. It's an apples to apples comparison. That's the point. You know, the point, for example, they come and speculate about calibration. Well, it couldn't have been calibration if the congressional race for CD13 was at the top of the screen and the AG race was at the bottom of the screen. So it couldn't be a calibration issue at that corner of the screen. That's the whole point. The point is it is voter confusion as a result of ballot layout. And the evidence in terms of statistical analysis is compelling. What they didn't touch upon is the fact that Professor Wallach said that's exactly what you have to do to prove that theory. We did exactly what their expert said, as you saw in the cross-examination, exactly what their expert said that had to be done to prove that theory, and we proved it.
And it wasn't you. There was another attorney, I think, who mentioned that, or asked your witness if they were aware of ES&S contacting Sarasota about concerns over putting their ballot layout.
We have no role in ballot layout. That is not our
No, I understand that, but I mean, is there any? Did those conversations take place? Was ES&S?
Would we have known prior to the election? You're saying that the ballot layout could have been an issue?
No, I'm just wondering if there was any. Yeah.
We can ask the same question of them, since they had a right to appeal or object to ballot layout. They didn't know. You know, there are things that you look at after the fact and say, maybe in future elections, we should have a different ballot layout. But could Kathy Dent have done it? I think Kathy Dent is an extremely honorable public servant. I don't think she did anything wrong in this case.
Yeah, no.
I just wanted to clarify what you were saying before. You said you don't have a problem with a judge selecting an independent expert, to directly look at the code?
To review the state's source code review. The state is going to conduct the source code.
So who is it that you, I mean, because when Wallach was up there, he was talking about you could sign a confidentiality agreement. Is it that you don't want their experts to look at it?
Of course.
You just want,
Of course. Their
somebody
experts
else.
have an agenda and a particular political point of view. Now, it's ironic that they keep saying you should have an independent expert, and that's exactly what we're proposing.
You're both using the same wording. I mean, that's why I'm
Exactly.
asking. So you want
I
them to
guess
pick
it's a point
somebody
of
that
view.
basically we haven't heard from today, or else somebody an expert that you've chosen.
Somebody that's not hired by us, not hired by them. Somebody that's hired directly by the court that doesn't have an agenda and that can make that review. Can't be fairer than that. Thank you.
Thank you very much.